bad news. We have a bad news to report. Unfortunately, with those removal proceedings, things are getting worse. Okay, we have a matter of JHMH. This year, 2025, the BIA basically is giving the immigration judge power to ignore stipulations. Essentially, what happened in this case is the fact that the Department of Homeland Security and the respondent, which is the person in removal proceedings, they agree, the lawyers, right? The lawyer for the person in removal proceedings and the lawyer for the Department of Homeland Security, essentially ICE, got into an agreement. They stipulated on certain facts and they agreed to offer this woman a grant of deferral of removal under Convention Against Torture, what we call CAT, okay? But the judge disagreed. The judge denied the grant of deferral of removal under the Convention Against Torture. And the person appealed to the BIA, and the BIA dismissed the appeal because what the BIA is saying is that the judge is not required to accept stipulations. This is really uncommon because usually when we go to those immigration courts, sometimes they'll ask us to stipulate on the thing that we agree upon. Let's say the department and the lawyer that is representing the respondent, they agree on certain facts, on certain things, and on the type of relief that they agree on. They can present it to the judge, and the judge will look at the the case in its entirety and just decide, right? And most of the time, the judge will agree with those stipulations because we already, the department is not opposing what the agreement is. So most of the time, at least I can say 95 or 98% of the time, the judge will agree because we already enter into those plea, you know what I mean, like agreement. But this time, the judge denies this petition, and the person appeal, and the BIA sustained the appeal, which is going to make it really difficult for people nowadays to win on anything, pretty much, because if you agree, ICE agrees not to fight, but on certain issues, and the judge wants ICE not to fight. I mean, want ICE to fight. It's just gonna make it hard. They're saying that the job, what the BIA is really saying is that the job of the department is to fight grant of relief. They can't just stipulate on things and agree on those things. And that was a decision. They're referring to a decision that came from the Supreme Court, United States versus Texas. So that's they based their argument on that. Let me know what you think about this bad news. Really, this is essentially a really bad news, in my opinion, because it's just bad to know that you might agree with DHS to come up with a solution for your client, but the judge will disagree with that type of solution, and the BIA will essentially, basically, side with the judge. So this is really making it really hard. But anyway, follow for more. I hope next time I bring good news. I really hope so. Until next time, bye bye.